Good morning. This is Bernard Nomberg with the Nomberg Law Firm in downtown Birmingham, back for another session this week discussing some area of the law that affects our business and our clients. And today we're going to talk about mediation, compare it to trial in a workers' compensation case. In the last few weeks, we have been with you to discuss different areas of the law. We talked about the overview of the workers' comp laws a few weeks ago. We also talked about having compassion for our clients and knowing what they're going through. And then last week we talked about social media and the law and how it affects our clients. And this week, a little bit different topic. There are mediations and trials, things that we do every day, week, all throughout the year. These are the two most effective ways to resolve our clients' workers' compensation claims. The two most common. Mediation is much more common than trial. I think that has been the general trend, at least with Alabama workers' comp cases over the last decade or so. Not that many cases go to trial, at least our firm's experience in the last several years. A few go each year, but majority of the cases resolve through a settlement, typically either through a mediation or through just negotiations with the workers' comp adjuster or the insurance attorney who represents the employer and their insurance company. A small percentage of our cases go to trial, maybe a few each year, but the majority of the cases, 90+%, resolve through a mediation process. And I'll explain what mediation is. I'll explain what the advantages and the disadvantages are. And we'll also go through the same for what it is for a trial, to actually be in court in front of a judge, testifying and discussing the pros and cons of both. What we first really try to assess with our clients when we first meet with them is what are their goals for their case. Most of the time they want to, almost all want to be healthy. They want to have the medical care that they need from the injuries that they sustained on the job that was by and large not their fault, but the fact that they got hurt on the job under Alabama law, when a workers' comp laws apply to particular circumstances, they're entitled to have their medical care paid for their life for those injuries. And there's some other things, benefits that go along with that, but the clients typically will tell us they just want to get healthy. Also with that, because of certain circumstances that don't allow them to work while they're in the recovery process, they are not getting paid. But those are side issues that we could talk about another day, but the goals of the client are to get healthy and to be fairly or properly compensated given our laws. So when we ascertain what their goals are, we have to figure out from a factual standpoint what's going on in their case. Is it an accepted claim, a denied claim? What's the employer's position? So those are the things that help us to figure out what's best way to help out the client. Do we need to go ahead and file a lawsuit, or can we pursue it as a claim, and then as we go forward, as the claim shapes up over the weeks and months after first representing the client, do we need to proceed to a trial, or can we move toward mediation? And mediation, I'll explain, is a voluntary process where the parties come together with a third-party mediator, or an ombudsman as we call them, through the Department of Labor here in Alabama. The Department of Labor oversees the workers' comp laws and compliance and all issues dealing with the workers' comp laws for the state. And one arm of the Department of Labor is the Ombudsman program under the work comp section. The ombudsman have the authority through our laws to mediate cases, and they have a few other statutory authorities and abilities. But the mediation process is when the parties voluntarily come together to try to work out a deal, try to negotiate or hammer out a deal over a voluntary process, usually at either our law firm or the insurance defense attorney's law firm. And they take, it could be less than an hour, or it could be a few hours, or it could be an all-day event. But David and I mediate every month. We try to have multiple mediations in a day, and we have hopefully a few days each month set aside for that process. The fact that it's voluntary means that either party can walk away if they don't like the ultimate terms that are being proposed. But mediation is a hopefully one-day event that prevents you from having to go through the stress of litigation, a trial. It also has several advantages and disadvantages. And if you're just joining us, we appreciate you tuning into our weekly legal sessions talking about various areas of the law. I'm Bernard Nomberg, the Nomberg Law Firm in downtown Birmingham, and we handle Social Security cases for disability. We handle workers' comp cases, and we also handle personal injury, with work comp being the majority of the type of cases that we do. And today we're talking about mediation versus trial in a workers' comp claim or case. You can go to mediation at any point in the process, even after you filed a lawsuit. You can go to mediation all the way up to the day before trial. That's one of the advantages of mediation, in addition to being voluntary. So long as both parties want to get together to try to work out a deal, that's what you try to do. Some of the other advantages of mediation is that you get to resolve your claim that day, and hopefully some of the stress that you've been under will slowly go away. Not every mediation results in all the stress going away, but it's certainly a goal that some of the stress of the process can be resolved that way. Other advantages are that you can ultimately resolve your workers' comp claim for a lump sum settlement, as opposed to if you go to a trial, any money that's to be paid to you in the future is paid out weekly. A lump sum settlement is usually preferred by our clients, even if or even when they realize it would be a reduced amount that they might be entitled to if they go to a trial and the judge rules the full for them. Another advantage is most of our clients are dealing with Social Security disability at the same time. They're either about to apply for it or they're already on it. Well, when you mediate a case or settle your case prior to a trial, you can put certain language in the settlement documents that help you with what's called the offset. And I won't get into all those boring details, but it really helps the client to have such language when dealing with both workers' comp benefits and Social Security benefits. Some of the disadvantages of mediation is that when you start your negotiations, you're dealing with present-day money, which has to be reduced down to figure out from a lump sum settlement standpoint of negotiations. And both sides in the case, they know all of this, and there's no real hidden figures or aha situations. Everyone knows what kind of money you're dealing with when we're starting to negotiate. But you do compromise some of the potential money you could be negotiating for or hoping to resolve to receive. Another disadvantage, some clients have expressed that they don't get their day in court. They don't get to sit in the witness box and testify and be in front of a judge and just get out all of the frustrations and emotions. So a mediation can kind of rob that, because there's no testifying. It's just you're in different rooms. Usually my client and maybe a spouse of my client and myself are in one room. In the other room is the insurance attorney. Probably the adjuster is either there in person or they're on the phone with the attorney, and then the mediator or ombudsman goes back and forth during the process. So those are some of the advantages and disadvantages of mediation, but it is by far the preferred by our clients as opposed to trial. It gets much more attention than trials. Now, when we file lawsuits, we're always moving toward a trial, and it helps our clients' cases to shape up, to look more like we want to present it to a judge from an evidentiary standpoint. Trials usually are a one-day event at the courthouse, sometimes as few as just a couple of hours. Some days they take a whole day, maybe even spill over depending on how involved they are. So that's stressful to not only the clients but the attorneys and everybody involved. You never know what's going to happen from an evidentiary standpoint. You never know if the judge is going to buy into the credibility of our clients, and that's always the number one most important thing with us. Whenever we sign up a brand new client, is the client's credibility. If we don't believe the client, how can a judge or an adjuster or anyone else in the case believe that client's claim? And that is probably the most stressful thing for a client being on that witness stand. They have to tell the truth, of course. Does the judge believe what that client, their story? And that's an advantage and a disadvantage. If you have a very believable client, of course we want that client to be in front of the judge to be able to explain everything. And that, even if you have the very best of cases, the worst injuries, the worst accident, if the judge doesn't believe that client, then you're not going to get what the goals or the expectations are not going to be met for that client. Another advantage of going to a trial is that's the only time and place where you can put on your evidence, request of the judge to judge that evidence, and hopefully if you get a ruling in your favor, you can get everything you're entitled to under the law, which may mean benefits that are due to you that have accrued, meaning in the past, or future benefits. And without getting into too much of the nuances, that is an advantage of trying your case in court. Some of the disadvantages, as I said earlier, is you can't get that certain language that helps with the offset if you have a Social Security disability case. The judge may not believe your client, so the difference between a 99% disability and a 100% disability in work comp cases in Alabama is a huge gap. It could be the difference in a six-figure resolution to the case, mid-six figures, all the way down to the low five-figure type of a case. So there really are lots of advantages of mediation. There are lots more advantages for most of our clients in mediation as opposed to trying the case in court. Again, I'm Bernard Nomberg, and in case you're just now joining us, I'm with the Nomberg Law Firm in downtown Birmingham, and we're spending a few minutes talking about mediations versus trials in workers' comp cases. That's the type of work that we predominantly do at our firm. We do it every day and have for years, and really enjoy that type of work. When a client first comes to see us, it's very difficult to figure out until we get the whole story from them just what their needs are and expectations. And from there, we can figure out, do we have to file or need to file a lawsuit to get certain things accomplished for the client? Can we try to resolve the case through a settlement, mediation-wise, or just involuntary, a less formal, just picking up the phone and calling the adjuster or the workers' comp attorney. At any point in time, if you, those of you watching, have questions, you're certainly welcome to send in your questions, or you can call us at the firm at 205-930-6900. We'll be glad to answer any questions. We're on all social media, Twitter, and we have a Facebook page, of course, and a website that has questions and answers. Next week, we haven't figured out next week's topic. We're always open to suggestions, but we just wanted to spend a few minutes with you this morning talking about mediations versus trial in the work comp setting. And we hope you guys have a good rest of your day, and we'll catch you next week, next Tuesday at 10 a.m. Take care.